Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some legal news and perspectives they can use in their practice. As always, please recommend this podcast to a colleague if you find it useful.
And send it to your opposing counsel if you find it unhelpful. Before we jump into this week's discussion, we want to thank Casetext for sponsoring our podcast. Casetext is a legal technology company that has developed AI-backed tools to help lawyers practice more efficiently since 2013. Casetext is relied on by 10,000 firms nationwide, from solo practitioners to AmLaw 200 firms and in-house legal departments. In March 2023, Casetext launched CoCounsel, the world's first AI legal assistant. CoCounsel produces results lawyers can rely on for professional use, all while maintaining security and privacy. Listeners of the podcast enjoy a special discount on Casetext basic research at casetext.com/CALP. That's casetext.com/CALP. And as a bonus, that CoCounsel program does not make up cases when it spits out a report for you, which is a nice benefit.
Yeah, that is a feature very much in demand these days. All right, Jeff, well, we're very happy to welcome back to the show Ben Shatz. Ben is a certified specialist in appellate law. He has handled hundreds of civil appeals, writs, and petitions in courts, including the U.S. Supreme Court, U.S. Courts of Appeals, and California Supreme Court and California Appellate Courts. Ben served as law clerk to the Honorable Robert J. Johnson, U.S. Magistrate Judge for the District of Nevada. Ben publishes everywhere that California appellate law and news reviews are sold, including California Litigation, where he serves as editor-in-chief, and the Daily Journal, where he hosts his regular column, Exceptionally Appealing. And Ben is the proprietor of the Southern California Appellate News blog, a key tributary of legal news and views to this podcast, not to mention to judges and attorneys throughout the state and beyond. Ben is also a member and secretary of the California Academy of Appellate Lawyers, a subject that we talked about during Ben's last appearance on the podcast. And as relevant to today's discussion, Ben now serves as a member of the California Supreme Court and Courts of Appeal Bias Prevention Committee, chaired by California Supreme Court Appellate Associate Justice Martin Jenkins. Ben, welcome back to the podcast.
Thanks, guys. I'm delighted to be here. And yes, I wanted to speak to you on the topic of judicial bias in light of my recent appointment to the new committee. And the appointment was by our new Chief Justice. And if you don't mind, I'll just dive right in.
Yeah, and congratulations on that appointment, Ben. I do, and please do jump right in. But I'll just give you this prompt. I understand that the purpose of the Bias Prevention Committee is to eliminate bias from our courtrooms. But you shared with me that there's an article recently about a spike in judicial conduct complaints across the country, but I believe that applies to California as well. Tell us, if you would, in your introductory comments, introducing our listeners to the committee, tell us about that spike and what the committee aims to do about it.
Exactly. So we'll build up to the committee's mission and who's on it and all of that. But as background, I'll point out that last Monday, so just a week ago, on law.com, there was an article titled "Judicial Conduct Complaints Spiked Across the Country in 2022." And that article talked about how judicial conduct bodies all over the country received record numbers of misconduct allegations against judges last year. Now, why is that? I don't know. Maybe, and there's speculation that maybe this flood of misconduct allegations reflects a diminishing trust among the public and the bar in the country's judicial systems generally. But regardless of why, the article cites surveys from the National Center for State Courts showing that the percentage of registered voters who said that they were confident in state courts fell down to 60% in 2022.
Fell to 60% from what point?
Well, when they did the survey, I guess in 2012, a decade before, it was at 67%.
Okay.
So, maybe a 7% drop isn't that much, but it's something. And in particular,
it's statistically detectable, we'd say.
Exactly. And bias complaints are up over 4%. Now, the article also cited the California in particular. And in California, the Commission on Judicial Performance issues an annual report, and the 2022 annual report is available online. And it details over 1,200 complaints in 2022 against
and these
judges.
1,200 complaints we're just talking about California now?
Yes, California state judges. So 1,200 complaints in 2022, which I think qualifies as a spike from wherever they were before.
Okay.
But in particular, the report lists the sort of in David Letterman style, the top 10 types of conduct that results in judicial discipline. So now we're focusing on not just complaints, but actual discipline against judges in 2022. That's on page 18 of that report.
Okay. And are these all different types, these top 10 types of bias, or is this broader than bias?
This is broader. This is just, what got judges actually in trouble in 2022. Wow. Number one, of course, is demeanor and decorum, right? Things that judges do in courtrooms that count as demeanor or decorum violations. But number two is bias or appearance of bias, and specifically bias or appearance of bias not directed towards a particular class. So I think that sort of bias is when somebody just says, well, you're biased towards my opponent. You like my opponent more than me. I think that's what that is. Because number three on the list is decisional delay. So that's a different topic. And I imagine you've talked about that on this podcast as well. In particular, if you look at pages 25 to 27 of the report, there is a section there about the public admonishment of Justice Vance Ray. So, if you're an appellate person, you probably want to read those pages just about decisional delay. But then dropping down the list to number 10, we're back to bias and appearance of bias again. And this time it's towards a particular class, which I think is something like, maybe pro-law enforcement or favoritism for certain attorneys or appearance of bias about ethnicity and so forth. So, I mentioned this by background merely to show that nationally and locally here in California, bias statistics, to the extent that they are kept, are up. And so, I suppose the next question is, well, why would we even care about this bias or perceived bias? Why bother talking about it?
Before you move on to that,
yeah.
If I could just clarify, I was a little surprised when you mentioned those two different types of bias. The one that's number 2 on the list, which is bias not to a particular class, and number 10, the top 10 bias, or number 10 on the list, was bias toward a particular class. That's the number 10 spot is the one we normally think of, race, gender, ethnicity, religion type bias. But the actual higher ranked bias, the more proliferate bias, is you just like the other side. You like my opponent better than me. That's a much higher ranked, more prevalent type of bias than the traditional type of race, gender, class, or ethnicity type of bias. Is that
it's an odd distinction. I'm not sure, exactly how that came about and why the statistics are kept that way and what it means in particular, because I haven't made a great study of judicial discipline, but perhaps somebody at the CJP can peel that down. What caught my attention was simply that bias gets 2 notes, and in the top 10, bias is in there twice. So, it seems reasonable to talk about bias. And then, of course, there's just the obvious point that, courts are supposed to do their job. And fairness is the touchstone. Now, you might say, well, shouldn't courts be doing their job without any concern about public perception? Who cares about reports or what people think about the courts? But of course, if the courts are actually biased, then they're not actually doing their job of providing fair decision making.
Right.
And in particular, the court's role is to produce an outcome that even the losing parties will abide by.
Absolutely, yeah.
And to get to that result, there has to be some basic degree of respect for and trust in the decision maker and the process.
Yeah.
And this is why the ethical rules that exist always say that judges should not hear cases where there is merely an appearance of bias. It's not just, is there bias, but does it look like there might be bias? And so, that appearance of is a particularly important part of all of this.
Yeah. Well, and going back to that, and again, the number 2 spot on the list, the bias not to a particular class, but just bias that the judge liked the other party better. It makes me think of one thing that always stood with me when I was studying for the appellate certification exam, and I read the Rudder Guide on Civil Writs and Appeals from cover to cover. The very first, I think, page of it says that the most important thing to remember whenever you're evaluating an appeal is ask yourself, did the right party win? Because that's what the appellate panel is going to ask. If the right party won, then the panel is going to be loath to reverse. And if the right party didn't win, then this, I'm not quoting, of course, from the Rudder Guide, but there's more likely to be an incentive to try to find a way to reverse. And I wonder if that type of thinking, and of course, this is I'm not impugning this advice or this the Rudder Guide, but I wonder if this thinking is, well, the other side just thought that the other side deserved to win and twisted the law to get there.
But it's interesting to note that number 2 sort of bias represents the second most common basis of actual discipline. So it's not just people complaining. It's that there was some investigation and there was something to it. Because of course every loser is going to think, oh, the other, the judge just liked my opponent more for some reason, and they were always out to get me, sort of thing. And as my former friend and the mentor, the late Judge Schiavelli used to always say, every time a judge makes a decision, he makes one temporary friend and one permanent enemy. So there's always that. But we're peeling this back deeper, and to get there, to sort of build up to where we are today. I want to go back and do a little bit of quick history on bias prevention in the courts, because for a long time there wasn't ever any discussion about it at all. The courts were the courts, and nobody would dare question anything that they would be doing. And I want to start the story here in 1982. In 1982, the New Jersey Supreme Court formed a gender bias task force, which was a new, amazing thing at the time. Now, after that, over time, 40 other states and the federal courts all formed similar task forces. But it's interesting to note that the formal discussion of bias begins with gender bias. That's where it starts, because you suddenly have lots of women appearing as lawyers in the courtroom, and they're all complaining that they're not being treated in the same way as their male counterparts. So now, in 1987, here in California, the Judicial Council adopts California Standards of Judicial Administration, Section 1. So number 1 is addressing bias in court proceedings, and there's a general statement there on a judge's responsibility to prohibit bias, and that's language we'll come back to. So it imposed on judges a duty to ensure that courtroom proceedings, and we'll focus on that too, are conducted in a fair and impartial manner, and that the courts are to refrain from any conduct and prohibit others in the courtroom from engaging in conduct that exhibits any bias, and to ensure that all of decisions are free of bias. So we have these judicial standards of administration, which are you can find them in the back of your rules of court if you still actually have a printed book of the rules of court, or even in the online version. There's 10 titles of rules, and then there are these standards that probably lawyers never look at because they're directed towards the courts themselves. But there's a little bit of gold in there. So look at those judicial standards of administration. There's even a chapter in there just about the appellate courts. But the only thing in there is a standard 8.2, I think, that says something like it's okay to do memorandum decisions. But the standard 1, as it was back then in 1987, applies to all courts. And it's sort of a basic statement that you would all assume, everyone would assume should be part of how courts operate. And so in 1987 and then 1988, 2 successive chief justices, Rose Bird and Malcolm Lucas, appointed a judicial council advisory committees on gender bias in the courts. So again, going back to this notion of even in the 80s, let's look at gender bias. Similarly, in 1988, the Conference of Chief Justices adopted a resolution emphasizing a concern that all participants in the judicial system be treated fairly. And they urged that every chief justice in every state established task forces devoted to the study of gender bias, again, but also this time they phrased it as minority concerns as they relate to the judicial system. Probably not the language we would use today, but this was considered cutting edge back then.
Yeah, so
right?
So by 1988, we're broadening it from eliminating gender bias to addressing other forms of bias.
At least that's the push from the National Council. So again, coming back to California, in 1990, the gender bias finally issues its report. It publishes Achieving Equal Justice for Women and Men in the California Courts, a draft report of the Judicial Advisory Committee on Gender Bias. That came out in March 1990, and the Judicial Council then adopts a comprehensive set of recommendations to ensure gender fairness in the courts. Similarly, in 1992, so we're inching forward in time, California Judges Association conducts a comprehensive review of the Code of Judicial Ethics, and it issues canons 3B, 5, and 6, setting forth affirmative duties on judges to perform all their judicial duties without bias or prejudice, and to require everybody under a judge's direction to refrain from conduct. So it's spreading to, it's not just for judges, but it's for clerks or bailiffs or, anybody else that a judge can control.
And just to flag for our listeners here, after we do this city bus tour through the history of bias prevention, we're going to talk about a few case studies and examples of the types of bias that are being addressed by these measures. So you can see some actual, what are we talking about? What are the actual types of bias that's occurring in the courtrooms? We'll see that in just a little bit later in the conversation.
So now we're up to 1993, and again, back to the Conference of Chief Justices. They urged further efforts for equal justice by encouraging task forces to remedy any discrimination and to implement the recommendations of any of the task force studies that have come before. Also in 1993, here in California, there was a commission called the Commission on the Future of California Courts. And that commission, within its report, which was titled Justice in the Balance 2020, so they were looking far into the future, 2020, issued this report, and they designated gender fairness as a high priority, again, back in 1993. Now, also in 93, something interesting happened. The Judicial Council amends Standard 1 that I mentioned to add a recommendation that all courts are supposed to create local bias committees and to adopt informal complaint resolution procedures. So having recognized a problem, they say, okay, well, the courts need to do something about it. Every court should be doing something about this, and they should have a process in place to allow people to report on it. In 1994,
and sorry, Ben, this is directed to the California Superior Courts or district courts?
All courts. These
courts.
are judicial standards for the judicial system. So, pick your favorite court.
Yeah.
Now, because they're supposed to be local committees, presumably it's more local based. The Supreme Court covers the whole state, but the idea is that courts are supposed to be doing these things.
Yeah.
General standards.
What was there funding available for these committees and for these procedures to be implemented?
I would doubt it, right? I don't think there was anything particular. I mean, again, these are recommendations, right? That were made, so the top down says, hey, here's an idea, people should do this. I'll also mention in 1994, a report came out called The Effects of Gender in the Federal Courts, the final report of the Ninth Circuit Gender Bias Task Force. And you can see that in the Southern California Law Review, volume 67 in 1994, where they talk about what's happening in federal courts. And there's a reference there to, there were reports by judges speaking to their own secretaries in inappropriate ways, calling courtroom deputies "my girl," things like that. So, the gender bias is still at the forefront then. And I remember practicing back then, and I remember reading about how there were judges in California that would have sort of unfair sartorial standards, right? Like women lawyers were not supposed to wear pantsuits or something. I mean, there were things definitely happening everywhere.
Yeah.
So finally, let's move up to 1995. That Futures Commission that I mentioned finally issues its recommendations about gender fairness, and they have the final report comes out in April 1995. In 1997, the Judicial Council amends Standard 1 again, and this time they broaden it. They say that bias is prohibited on the basis of disability, gender, race, religion, ethnicity, sexual orientation. So we're entering the realm of not just looking at gender bias, but trying to encapsulate all of these categories.
Yeah, and this is the first expression of that since you mentioned this whole thing got kicked off in 1982 with the New Jersey Supreme Court Gender Bias Task Force, and then 5 years later, it includes the term minority bias, and now here we are in 1997 to finally see the more modern expression of disability, gender, race, religion, ethnicity, and sexual orientation.
Well, at least to start, right? I mean. Yeah. I think that what we've got now would go far beyond all of that as well. But yes, it's broadening. Arguably, you could say, well, that should have been baked in to begin with. But it's always better to spell these things out, right? Especially with the focus on all the gender attention. Maybe these other things weren't getting the attention that they deserved as well. So in 2007, the standard number 1 that we've been talking about gets renumbered, and it now becomes standard 10.20. Which is where it is today. Now it's not substantively amended, but it's moved. So that if you're somebody who believes like, well, standard 1 should be the most important one, you might wonder, well, why did we get bumped to section 10? But that's how it was done. So if you're looking for this, following along, you now need to jump to section 10.20 to see where we are. We'll jump ahead again far. So if that was 2007, let's go to June of 2020. Okay. In June of 2020, all kinds of things were going on in this country. But if you were an appellate lawyer, one thing other than the pandemic you might have been paying attention to was that the Commission on Judicial Performance ordered Justice Jeffrey Johnson removed for misconduct based on his disrespectful misconduct towards women. There were 17 days of testimony in August through October of 2019 with over 100 witnesses. So it was a big deal, and something like that had not happened, I think, in the history of California appellate practice.
Yeah, and it's staggering that if there are over 100 witnesses, this happened over a very long amount of time.
Yeah, there's very deep documentation on that whole event, but I just mention it as one thing that's relevant to this history as we're telling. And it's interesting. This goes back decades to, hey, let's pay attention to gender, and yet nothing really happens. At least there's no discipline at an appellate level for something like this up until 2020. The other thing, of course, that happened in June of 2020 is that the California Supreme Court, as did many other Supreme Courts in the country, issued statements about the George Floyd murder. And the California Supreme Court issues this statement on equality and inclusion and court fairness, and it's signed by all the justices. And it says, we condemn racism in all its form, conscious, unconscious, institutional, structural, historic, and continuing. And it asserts that the fundamental mission of the courts is to ensure equal justice under law for every single person. So, here we have a statement just issued by the Supreme Court in light of current events. And so people are paying a lot of attention to this. And what happens? Well, the legal press starts looking into it like, well, so yeah, where are we after all of these reports and recommendations decade after decade? The California Employment Lawyers Association comes out with a report that says, guess what? Nearly all courts are not complying with Section 1020. And the Daily Journal starts issuing these stories in the paper, saying that, well, here's, there are 22 courts that don't have those local committees that were recommended by Section 1020. So there's an article called 22 Counties Not Complying with Bias Committee Recommendation. And then in July of 2020, there was another article, Bias Committees Are Enigmas, Attorneys Say. Basically reporting like, oh, wait, are these things supposed to exist? I don't know anything about them. And then there was another, that was an article in August. Then there was another article in court leaders developing judicial guidelines, right? So anyway, there was a lot being published around this time because there was attention on this topic. But what was coming out was, wait a minute, there really isn't anything out there. How are we supposed to address bias? And where are these committees that were recommended years ago? Nobody seems to be able to find them. So in November of 2020,
and Ben, if I could just break in a moment there, and speaking of that these bias committees are enigmas. When the Supreme Court made its statement about George Floyd in June of 2020, was that made in conjunction with the bias committee, or are courts acting separate from the bias committees, or is there any coordination about the public relation message, for lack of a better term, from the judiciary?
That message came from the Supreme Court itself. And I don't think that there was any committee involvement. In fact, that was probably one of the problems, is that there weren't any committees. It was just something that the court itself recognized it should do. And I think a number of the courts of appeal also issued similar statements, endorsing or following what the Supreme Court had done. So that takes us to November of 2020. And to your point, the Chief Justice at that point appoints what was called the work group to enhance administrative standards addressing bias in court proceedings. So there's maybe a committee, right? A work group was created that was supposed to identify improvements and amendments to Section 1020. And that was chaired by the Fifth's PJ Brad Hill and then Judge Stacey Boulware-Urey. And there were work group members on that, included Justice Karen Fujisaki, presiding Judge Joyce Hendricks from Humboldt County, LASC Judge Kevin Brazil, San Bernardino Court Executive Officer Nancy Eberhardt, and some private attorneys, Rachel Hill and Gretchen Nelson. So this work group is created, and about a year later, in 2021, the work group issues recommendations. And the recommendations are pretty interesting. So first of all, there are a few I want to focus on. One is that they come out and say, the goal for the courts should be to prevent bias, not just prohibit bias, because that was the original language. So they're trying to get it to be more active, right? And then also that the scope of this should be expanded to all court interactions, because again, the earlier language was things that happen in the courtroom. And there can be expressions of bias outside of the courtroom. If the court clerk isn't taking your documents, or is being rude to messengers or lawyers or litigants who are trying to file things, or if other people who work for the court related to the court are acting in a biased way, that's a problem too. So it's expanded to all court interactions, however broadly you want to define that. And then, of course, they updated the list of protected classifications because, as we just went over, it's expanded. But if you were to do that today, which has been done, it's going to be a lot longer. There are more forms of protected classes. And then they turn to the idea of these local or regional bias committees, which for the most part didn't even exist. And the question is what should their optimal role be? What is it that they should be doing? Assuming they can even get off the ground. And more particular then, the task force says we have to ensure that court users, which are lawyers, the public, litigants, can access information about how they can even complain about court employees and judicial officers. Because it's not easy, right? If you may think, where do I click here to complain about a judge? I'm not aware of a link for that. I mean, and is somebody, a member of the public, going to realize, there's something called the Commission on Judicial Performance, and maybe if I find them on the website, I might be able to find a way to do something. So, the recommendation was that there's got to be some way to make this easier and make it known and available. So those were the recommendations of the work group, which now brings us to 2023. This year, the Chief Justice Guerrero then appoints the Supreme Court and Courts of Appeal Bias Prevention Committee. Not just a work group, but an actual committee. And the membership on this committee is composed of justices from the Supreme Court and each Court of Appeal district, and a court administrator and attorneys from each district that are practicing in the appellate court. So basically, there's 7 justices, 1 Supreme Court justice, an appellate clerk, and there are 7 lawyers. And then I'm going to, and I'll name them in a moment. Plus, P.J. Hill and P.J. McConnell are advisors to this committee. But so who's on the committee? This committee is chaired by Supreme Court Justice Martin Jenkins, and on the committee you have Justice Helen Bendix, Justice Stacey Boulware-Urey, who at this point is now a justice, Justice Doe, Justice Karen Fujisaki, Justice Lee, Justice Rosendo Pena, and then the Second District Court of Appeal Executive Officer Clerk Eva McClintock, and then on the practitioner side, Deputy Attorney Generals Amit Kurlikar, Deputy Attorney General Charles Ragland, the Central CAP Executive Director Laurel Thorpe, and then some private attorneys, Charles Sevilla, Rasha Gurgi Shields, Rupa Singh, and me. So there's your cross-section of the appellate bar and the appellate justices trying to cover the whole state and covering different practice areas to get together to be on this committee. And the appointment letters were issued in March. And there's been one in-person meeting of this group. And one of the things that came out of that meeting was a mission statement. So I want to read the mission statement. And that is, pursuant to standards of judicial administration, standard 10.20, the Supreme Court and the Courts of Appeal Bias Prevention Committee aims to support the integrity and impartiality of the judicial system and promote an appellate court environment free of bias and the appearance of bias. So there you have a mission statement. And the committee, of course, is going to try to focus and will focus on how bias manifests itself in all court interactions with the goal of identifying some practical objectives and some programs aimed at preventing bias in the appellate courts.
Hey, Ben, can I ask, so is the goal at the end of the process to have some recommendations that will like go up to the Supreme Court or go to the what is the end product of this committee?
Well, that's a great question. And I mean, it's not a workforce or a task force like the original one. It's not like get together and come up with some ideas, although that's always true of every committee. But I think that this committee is supposed to do that and more to the extent as possible. So in some sense, yes, I suppose we're going to try to come up with ideas, and more importantly, to try to implement those ideas. Now, the reason I mentioned everybody who was on this committee is because there's an ask here. And the reason that I wanted to do this podcast was to get this message out with a particular ask. And the ask is, if you have ideas for this committee, contact me or anybody else that I just named, because this should be a public process to try to gather information and ideas, and in particular, report any bias that you're aware of. Because as things are now, I don't think there's an easy way to do that. Already there's a reluctance, especially by the bar, to do anything like that, and by court staff. It took a lot of courage, I think, for people to come forward against Justice Johnson and make their allegations, and it was a long process there. But it would seem to me that every Court of Appeal website, because each of the districts has one, maybe there should be a link there that says, if you have something to report anonymously, click here. But even then, there's reluctance for anybody to do that, and so it would be nice to gather some information.
Yeah, Ben, here's one question and possibly a suggestion based on when you mentioned there's an open question. How do members of the bar or how do members of the public submit complaints? Because it's you mentioned it's not at all clear exactly how to go about doing that. One way that most people at some point or another, if they're litigants, figure out how to do is to file a 170.1 challenge for cause, which which almost just go away. They're not filed for good grounds. But I wondered, I was reminded
but you can't do that on appeal. And remember, the focus of this committee is about appellate bias.
That's right. Yeah.
So, we don't even have that to work with. I suppose in theory, people can file motions to recuse a panel member or something. But I mean, how often do you see that? How would you track that down? And that's probably not really what we're getting at, because you don't typically see a motion that says, I don't want Justice so-and-so on my panel because Justice so-and-so doesn't like people of this certain type. I mean, I don't think you ever see something like that.
Yeah, that's right. I wouldn't know how to advise a client to do that. You write a letter to the court, or you could file a petition for rehearing after the fact, I guess, if you find something afterward. But yeah, very few options.
And I do have an anecdote to share about that, but I want to complete my thought on the ask. In addition to having the courage to report bias if you see it, and ideas for the committee, to the extent that your local court or region has a bias committee, which was recommended long ago, you should volunteer for it. And if it doesn't, maybe you should step up and start working with whatever bar associations you're involved with to say, hey, there's supposed to be this thing and I don't know where it is. Let's make it, or let's do something about it. So, I would encourage that. Now, I'd also say, for appellate lawyers, it's maybe an unusual thing, because I've been in the appellate world now for at least three decades here in California. And as much as people like to complain about everything, I don't really think I've heard a lot of bias complaints in the appellate chatter that's out there. But maybe people just don't want to talk about it, or they're not talking about it with me. So I'd be curious, from your perspective and from the perspective of the broader bar, how do people feel about our appellate courts? My view was always that they are essentially pretty fair and bias-free. And I don't just mean the justices, I mean all the way down through the court staff and so forth. They're not perfect, and there are definitely problems, but the problems have never seemed to be hinged on bias. But what do I know? Maybe there's more out there, and so we would love to find out.
Yeah, I think that's an important question to ask to our community to see if we get any comments coming in about what types of bias they may be seeing. Because I agree with you. I think there is a filtering mechanism by the time a judge is elevated to a court of appeal justice. There's been a kind of sorting and filtering mechanism. We don't tend to get those bad apples failing upward, so to speak, to the appellate bench. I think from what we all 50% of the parties and litigants are unhappy at the end of an appeal, but still, I think, like you said, Ben, the system is designed in a way so that even the unhappy party feels that they got a fair shake.
So, we had promised some anecdotes or maybe citations about such things. And so, we can start marching down that list. And this is by no means exhaustive, but I pulled a few examples. Going back to 1973, there's a California Supreme Court case, Geiler versus Commission on Judicial Qualifications, 10 Cal 3rd 270, where a judge was removed for subjecting female attorneys in chambers to salacious discourse on aspects involving a rape trial. And, again, we're back to the old gender bias stuff that was going on. Similarly, actually in 1983, there was a pretty well-known incident in New York where a state judge in New York was publicly disciplined twice for calling a female attorney a little girl. You hear that sort of thing. I think there's a lot less of that going on these days.
I used to have a female partner. My law firm is a 2-partner law firm, who in the early aughts, had a retired discovery referee in Orange County refer to my partner as little lady. And what can we do to make this little lady happy in terms of a discovery order? I was flabbergasted. Yeah, it still happens.
Yeah, it does.
Yeah.
So let's see, 1988, 45 Cal 3rd 518, there's a Ryan versus Commission on Judicial Performance, where a judge is removed for misconduct, including telling sexual jokes in chambers to female attorneys. Just not a good idea, right?
Yeah. Well, yeah, and regardless of the gender, it's inappropriate.
Yeah, exactly. And on the federal side, in the Eastern District of California, in the In Re Plaza Hotel Corp case, which is the bankruptcy citation, the court rebuked a debtor's lawyer who referred to the trustee's female lawyer as office help. So again, sort of the denigrating of the female lawyer. And on the criminal side, the United States versus Mast, Central District of California case in 1989, the court there justified a significant departure from the sentencing guidelines for a female who was convicted of bank robbery. And this was based on the theory that, well, she was dominated by her male partner in crime, and saying that, quote, "It's a fact of life that men can exercise a Svengali influence over women." So, there's a bias that actually is ridiculous, but it helped the woman in that case and her sentence. But it's just not right. Right.
Yeah, that's strange. It reminded me of an experience I had reviewing a case for a potential appeal, and I was taken aback by a comment made by the trial judge. It was on the judge wound up denying a motion for a DVRO on the basis of the judge had undergone some, not undergone, but had attended a training about how to rate the credibility of victims of sexual assault. And the judge said, well, based on my training, I've undergone extensive training on this, and I understand that when a woman doesn't have an sufficient emotional response to being asked to relate her trauma, that undermines her credibility. And I thought that just seemed like I don't know if it's sexist, but it's just a bad application of whatever training that judge got.
Yeah, and it definitely comes up in family law type matters. So in 1992, there's a published case called In Re Marriage of Iverson that overturned a divorce judgment in part because the trial judge was making biased remarks to the wife, calling her a lovely girl. Again, back to these patronizing comments from judges to female litigants.
Yeah.
And then, of course, there's plenty more citations to judges making sexually suggestive remarks to females in court or staff members. In Re Gordon in 1996 is a published case. More recently, and focusing on appellate courts now, there was the famous Martinez versus O'Hara case in 2019, 32 Calap 853, where the plaintiff's attorney commits misconduct on appeal, including gender bias, by calling a judge a succubus and being reported to the state bar. And the Briganti versus Chow case, also 2019, where a litigant called a female judge, who is now an associate justice on the court, attractive. And it's like, what? Talk about irrelevant and sexist. The Court of Appeal comes down on that. And
again, just completely inappropriate.
Yeah. So, there you have examples of appellate courts who are very attuned to this, looking out for other judges. It's the lawyers that are misbehaving. And it's perfectly appropriate for the courts to do that, because the courts are supposed to not only police themselves and their own staffs, but also the officers of the court, which are the lawyers. So, it goes both ways.
I wanted to ask you, Ben, about another case that was on this list here, Catchpole versus Brannon, which involved where the judge had interrogated a plaintiff in a sexual harassment action, and the Court of Appeal noted that the judge had taken a, quote, fatherly tone when interrogating the woman on the stand, and the tone was, quote, either courtly and patronizing or harsh and reprimanding, end quote, and it created a strong impression of gender bias. And I wondered, interpreting tone can be very difficult, and especially on appeal, as we know, when we're just looking at the cold, dry record, and how do we intuit the tone from the record? And isn't tone just inherently difficult to try to police after the fact?
Definitely, and that's a public published case, and people can take a look at that one as well. But, in that case, the judge also sort of improperly assumed that a woman's failure to aggressively resist sexual assault was a form of consent. I mean, so talk about the caveman mentality of gender relations. When you've got that, then it's easy to look back at the record and say, well, the judge was saying these things, and maybe you can intuit tone from the actual rulings.
Yeah. Well, but then speaking as appellate attorneys who know that ordinarily we would be up against, if we were the appellant there, and we'd have the substantial evidence standard, that very high hill to climb. But if we have another weapon to hand and say, oh, well, in addition to not being supported by the evidence, it was also sexist. It was evidence of judicial bias. Is that an additional weapon that can be used to challenge the fact finder?
Well, I mean, you use the record as best you can. As you point out, it's hard to overcome these things.
Yeah.
And the presumptions are going to be against that. But especially in certain courts that are known for looking out for this, that are very attuned to this, if you've got something good, I suppose you should use it. And even beyond, using it in your own advocacy, if there are in fact things going on that should not be going on, that should be reported at any court level, then they should be reported. But particular at the appellate level, where there hasn't really been much focus on this before. And
if you were the appellate's attorney that in this case, and you're looking at the record and you decided this may be a good issue to raise on appeal, but I would be concerned that the panel would say, well, if you believe that the judge, you're not just challenging the judge's fact finding, his prerogative as a fact finder, but you're challenging that it was the product of judicial bias. Mr. Shatz, did you file a complaint to the Bias Prevention Committee? And if you have failed to do so, does that waive or forfeit that challenge?
Yeah, and 9 times out of 10, you're going to say, well, there was no committee. I didn't know what to do. I didn't know how to do it, and I didn't want to alienate the judge even further because I already felt that things were not going well. So, who knows how that shakes out? But I mean, there is a distinction here between, your advocacy for your client and thinking about bias, and your obligation as a lawyer and as a citizen to make sure that the courts are functioning properly, regardless of how your case turns out. These are things that should be reported, and you shouldn't just be using it as a tool for your own client's interests. And I did want to share one more anecdote, because there is something a little bit theoretical about all this. And you may say, well, this doesn't come up in my cases. It's never going to be an issue for me. And so here's my story about this. In 2013. I was involved in a case called Ellis versus Toshiba, and it's a published case, 218 Calat 4th 853. And it involved a pro per plaintiff and appellant who was a woman and a lawyer, and she gets sanctioned, and she then appeals that sanctions, and she loses, gets referred to the state bar. And the opinion in that case was written by Jeff Johnson. Flash forward all the way in June of 2021. So, this is a published decision from 2013. So, 8 years later, roughly, she pops up again, and she files a petition with the California Supreme Court based on gender bias. And she argues, hey, wait a minute, I was a female lawyer, and look at Justice Johnson. He was removed, and so therefore, my case was decided by a biased, prejudiced justice, and I want to undo it. I want a second shot.
Yeah.
Believe me, I was surprised to receive that petition, and my client, my former client from years ago, was like, "Wait, what's going on here? Why are we even talking? We won that case ages ago. Is there any chance that it could be unraveled?" And of course, the petition was denied. I mean, in some sense, you could say that was quite ridiculous. What she was trying to do, and yet there you have a real world example of bias coming up, and and creating something that actually affects practice. Now, as I said, it didn't go anywhere in that case, but conceivably, in the right case, maybe there actually is something to an argument like that. And so, these are things to think about. And again, the call is out there for ideas and even anecdotes or stories about bias in the appellate courts, because it's hard to address it if we don't even know what exactly the real problems and targets are. One thing that's come up is the use of names in appellate opinions, and in particular, Spanish names and the Asian names. It's not always used consistently, right? Like, you have John Smith versus Mary Rowe, and so you've got Smith versus Rowe, and that's easy. But have you ever noticed how a lot of times the Asian names, the full name is always used? So it's like there's a different treatment there. Now, maybe that's because in many Asian cultures, the surname is actually the first. But haven't you ever wondered about that? Like, we all know Yik-Wo versus Hopkins.
Right.
Why isn't it just Woe versus Hopkins?
Right.
Yeah. And maybe maybe that's a good thing, but it's certainly a different thing, and it's something that I've noticed. And similarly with Spanish names, there's a lot of issues there. First of all, there are special characters and accents and things that sometimes don't get used. I think that having Justice Cuellar on the Supreme Court helped with that a little bit, getting some of those accent marks used properly. But there are different ways that Spanish names are created, and if you're a student of literature, like Ortega y Gasset and things like that. And some of them get quite long and complicated, and the way that that's done, the names don't always seem to match, the Anglo perspective of everybody has the same last name in the family, but it doesn't work that way. And also on court forms, a lot of times there isn't a way to put in sort of the full official Spanish name, because there are multiple names that go into creating the last name, and which one really is the last name? Do you use the first part of the last name or the second part of the last name? So this is something that's come up and is an issue in California. And so, maybe there should be some guidance in the California style manual, more than there is, about, the appropriate use of litigants' names in court opinions. But, that goes into some cultural sensitivity. Right.
Hey, Ben, I have a question. One of your calls to action was for people to get involved in their local committees in terms of bias. A big chunk of our listenership is in LA and Orange County. Do the LA County Bar and Orange County Bar have active committees dealing with the issue of bias?
That's a great question. I don't know the answer to that. I know there are probably committees that are sort of in the ballpark there. I know because there's been so much done about diversity these days. Every law firm now has a diversity officer of some sort, and all the bar groups have diversity committees. But I'm not sure that there's been a focus on the local bias committee and how that can be used. There has been a lot of education lately and MCLE requirements on elimination of bias and implicit bias, both in the judiciary and at the bar. And that is definitely part of what, this appellate committee is supposed to be designed to do. And so in that sense, some of the work has been done and is out there. But more needs to be done. And I think more needs to be done to make it clear and obvious where all of this can and should be. And the current standard 1020, talks about how there should be information regarding how to submit complaints about court employees directly to the court, or how to submit complaints about judicial officers to the CJP or elsewhere. That should be out there, and I'm not sure that it is. I don't think that there are easy and ready easy ways to do that, and so that's something that probably needs to be upgraded. And in terms of the appellate courts in particular, the standard 1020 mentions appellate courts when it talks about local or regional committees, because of course appellate courts cover more than one local bar group or region most of the time. I suppose Orange County is an exception, right? But appellate courts can form separate or joint appellate committees or join trial court committees and regionally. And so, basically, all ideas are on the table. And as I said, this new committee that's been formed that I'm on is focused on everything statewide. And so, whether we keep it broad or we go more narrow doesn't matter. The point is we need to get the message out there. So I appreciate you allowing me to talk about this and put out a public call and see what we get back. And I very much look forward to hearing what feedback you gentlemen get from this podcast.
Ben, do you have any sense of the volume or scope of complaints that might be out there? And again, we're talking about a committee that's directed at bias in the Supreme Court and the courts of appeal in California, not trial courts. So I don't know if that's been studied before. And as you mentioned, we have 170.1s, 170.6s. We have that procedure for trial courts, but nothing for the courts of appeal. For the appellate courts. So I wonder if you have any sense of how many complaints might be out there. Once you put that portal up, are you going to get flooded, or is it hard to imagine that there's going to be a lot of complaints?
I think we don't know, and so that's why we need to do it. But even if nothing comes in, remember the broadened scope of this is that the courts should be preventing bias, not just prohibiting it and not just being reactive to, oh, well, here's a complaint, so we should do something about it, but affirmatively making clear to the bar and to the public, really, that the courts are fair, that there is not bias. How do you persuade people that is true? And what can you do to get out ahead of any problems, and what sort of programs can be done, or public messages? In the wake of the George Floyd murder, a number of superior courts, Santa Clara is an example, issued video statements on their websites where they had a bunch of judges from the court saying, we are here for you, and we are going to be fair. We decide our cases impartially and without bias, and you can trust us. And it may be that more of that needs to be done. Again, as lawyers, I think we sort of assume the basis of the system is it's going to be fair. We may believe that, but it's not necessarily clear that the public does. And all of the studies that have been done are showing that the faith in the judicial systems generally is declining.
Right. Yeah. And as you mentioned, the objective is not just fairness, but the appearance of fairness. And we can't quite say that, well, we haven't gotten any complaints when we don't have a way to submit complaints. And I wonder if some of the complaints that would be submitted would be more along the lines of sociological or economic type studies, comparative studies. Well, in this, when you slice and dice substantial evidence appeals, it affects minorities, women, other ethnic minorities are the losing party more often. Wonder if we might start getting those kinds of economic type analyses. But like you said, we have to. You have to open it up and see what kind of issues come up. So I think it'll be a good teaching event for everybody.
Well, and that is the point.
All right. Well, we're definitely going to put that call out to our listeners to report any kind of bias and what types of now, Ben, is there? I think you mentioned that there's it's still in the works. What type of portal? What type of complaint procedure is going to be set up? Correct.
Yeah, I mean, look, the committee has met once and come up with a mission statement. Nothing actually has been done yet to point to and say, click here for your ideas. And again, that's why I mentioned every committee member by name in this podcast, so that there are choices in terms of who to reach out to. It's not a secret committee,
right?
And every lawyer has email addresses, so. So you can send emails, and if somebody wants to send something to me anonymously, I will keep it anonymous. Yeah.
Yeah. Yeah. Okay, well, Ben, this has been invaluable. We're going to wrap up here. We want to thank you for your generous time in putting this presentation together. Really learned a lot and very thought provoking. We want to also thank Casetext for sponsoring the podcast. Each week we include links to the cases we discuss from Casetext's daily updated database of case law, statutes, regulations, codes, and more. Listeners of the podcast enjoy a special discount on Casetext basic research at casetext.com/kelp. That's casetext.com/CALP.
And if you have suggestions for future episodes or guests, and certainly if you have suggestions for the Bias Prevention Committee on how it can solicit complaints and what types of issues to be on the watch for, please feel free to contact us. We will get that information along to Ben, or you can contact Ben and we will put the other members of the committee in the show notes so you have ready access to send those suggestions to the committee members. And with that, we will see you next time. And thanks again to Ben Shatz, our guest today.
Thank you.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.